In today's video, we're going to look at funding a trust. 5 miscellaneous facts that I've run into in my practice recently that I thought I'd share with you. My name's Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. As always, first of all, this video is for educational purposes only. I am not giving legal advice. And second, we're going to be talking about Minnesota law primarily. So if you're in another jurisdiction, make sure to talk to an attorney in that jurisdiction about your estate plan before you go to plan your estate. Trust funding. What do I mean by the term trust funding? Well, it's a simple term of art that very simply means putting stuff into the trust. Remember, a trust is a weird legal entity that only has authority over those assets that are actually in the trust. Until it's in the trust, it's not a trust asset. Trust can't control it. So let's go right to fact one. Big one. Trust funding is not only for revocable living trusts. When we talk trust funding, it's a little bit of a misnomer that we only talk about revocable living trusts because, of course, that's the big one. If you have a revocable living trust and you forget to put your stuff in it, it doesn't do you a whole lot of good. But there is another type of trust that's important to be funded, and that is the testamentary or nested trust. A testamentary, if you've watched my other videos, is a trust that is formed in a will that comes into effect when you die. A nested trust, same thing, also called a subtrust. That's part of a revocable living trust that comes into effect when you die. So sometimes an asset doesn't get put into the trust until the trust, well, first of all, the asset can't go into the trust until the trust comes into effect. So think about the testamentary trust and a will. The trust doesn't exist until you die. So how can you fund it? The way you do that is you update the beneficiary designations on various assets. Let's take life insurance, for example. Instead of saying life insurance first primary beneficiary is my child Bob, I'm going to say if I do that, the assets will immediately go to my child Bob, held until the age of 21. If, however, I want the assets to go into a testamentary trust to be held for him until, say, the age 28, what I would do is I would change the beneficiary to be the actual trust. Second fact, number 2, trusts are a legal fiction. That's right, they're a legal fiction. We just kind of made them up at some point. Don't know when, we just did. They're kind of like a company and an LLC, but not entirely, they're not really their own entity. Here's the legal effect of it without going into the details. When you give to a trust, you don't say, I give, or for instance, I make the beneficiary of my life insurance the trust. You give to the trustee of the trust because a trustee is the only thing that can actually accept the asset. Now, if your attorney or you screwed up and gave the asset directly to the trust, I'm not sure what would happen. It would be interesting to see what the courts would do. Couldn't find any case law regarding that. But in any event, the best way to give an asset or to make a beneficiary designation to a trust is to give to the trustee of the trust. Third, there are 2 ways to fund things. First is through things that are by changing the ownership of an item. For instance, if we have a deed or a title, a deed to a property, a title to a vehicle, you change the owner of the deed or of the property or the vehicle to actually be the trustee of the trust. For accounts, bank accounts, you can actually have the trust be the owner or the trustee of the trust be the owner. And for random miscellaneous stuff in your house, such as your clothing and your kitchen stuff and whatever else you have, your tangible personal property, we generally do a general assignment of tangible personal property. Once you sign that document, magically everything is in your trust. The second way to fund your trust is through beneficiary designations. We've already talked about this a little bit, doing a testamentary transfer. The 3 basic types you're going to want to do are retirement accounts. We're going to talk about that in just a moment, but making the beneficiary of your retirement account to be the trust. You're not going to want to do this in all situations, but you're going to want to do it. Insurance, like life insurance, of course, make the beneficiary the trust. And there's also hybrids. You can do pay on death accounts for bank accounts or transfer on death deeds for real property. Fact 4, let's talk about retirement accounts. They're a little bit special. You do not want to change the owner of a retirement account to be the trustee of the trust. What that does is it incurs an early withdrawal penalty. The early withdrawal penalty, last I looked, was 20% if you withdraw an asset before the age of 59 and a half. Meaning that if you transfer it from yourself, the ownership of the retirement account from yourself to your revocable living trust, that's a taxable event and a withdrawal event, and you're going to suffer a 20% penalty. We don't do that. So in those cases, what we will do is we will make the retirement account beneficiary be the trust. Now, there's a lot of financial advisors out there that are going to be watching this and be screaming, don't do that, don't do that. That's not a good idea. You're right. If you're going to make the retirement account, transfer it, make the beneficiary a trust, you have to do some very careful things, specifically with the Secure Act. Otherwise, you hit early withdrawal requirements. So be careful, talk to an attorney before you go ahead and do that. Fact 5, forgotten assets. What happens if you forget to put an asset into your trust? Well, if it's not in the trust, then the trust doesn't control it. But you go through life, you make up your trust, 20, 30 years later you die, and you know what? You've changed cars by that point, and you just forgot to put your new car into your trust. What do? Well, we have what's called a pour-over will, and this is a will that does 3 things, one of which is if you forgot to put something in your estate into your trust, it says, let's put it into the trust, either through probate or through a probate alternative. Now, when I say probate alternative, right now I'm referring to an affidavit for collection of personal property. This is a small estate administration option given in Minnesota that provides that if the total assets that are probate assets are under $75,000, you do not need to go through probate. You can immediately sign an affidavit and have control and transfer of those assets. Now, if it's over $75,000, you're going to have to go through probate. So it's great to have a revocable living trust, but if you forget to put all your assets in there, you're still going to have to go through probate to drop everything into the trust and then distribute it out from there. So you've actually created more work. One thing on this, sometimes people do purposefully leave things outside of their revocable living trust. For example, cars. We tend to buy and sell cars a lot more often than other assets, and it's a major assets, and retitling it is a pain because you got to go to the DMV, and no offense to DMV people out there, but it's not all that easy. So often what we do is we just keep the vehicle titled in our name and then use the pour-over will to transfer the vehicle into the trust. The second thing that often people leave outside of trusts are bank accounts. At least one bank account, just to make it a little bit easier. I'm not sure how much easier it makes, but some people do prefer to keep one active bank account outside the trust. Therefore, theoretically, you don't have to sign your name as trustee of the blank, blank, blank trust, dated whatever. If you set up a trust properly, you don't actually have to do that and identify yourself as trustee of the trust when you're signing checks, but that's just make sure you set it up properly. So that is 5 miscellaneous facts about funding a trust that I've run into my practice recently. I thought I'd share with you. I hope you liked today's video. If you like today's video, please feel free to hit that like and subscribe button. It actually really helps support the channel. We do new videos every other Wednesday. If you've got some questions, feel free to leave them in the comments below. I'll try to get back to you, or just send me an email. Happy to take your questions. Otherwise, until next time, this is Gregory Singleton from Signature Law.